Ladies and gentlemen, welcome to the National Constitution Center. Yay, indeed. Let's have a hand of applause for the National Constitution Center. It is so wonderful to see this full house, this great community of lifelong learners here today. And it is time to inspire ourselves by reciting our mantra. So recite along with me, and remember, we're going to do the full version, not just the attenuated one. The National Constitution Center is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. And then here's the second part: in order to increase awareness and understanding of the Constitution among the American people. That is why we are here today. We are here to spread the light and educate ourselves about a crucial constitutional question in the company of one of America's greatest constitutional scholars. Cass Sunstein sells out every time he comes to the National Constitution Center. And part of it is the wisdom of Cass Sunstein, because his topics have been varied and memorable. 2 years ago, he was here to discuss conspiracy theories. His last visit last year was Star Wars and the Constitution. And some of you came in costume. And today we are here to discuss impeachment from a nonpartisan perspective. And that's going to be one of my first questions to Cass. Before we start the show, I have to tell you what an exciting month it's going to be. Tomorrow, we have a lunch program. Hank Meyer on Arthur Vandenberg, the man in the middle of the century. Vandenberg was one of the greatest bipartisan senators of the 20th century, and it's an inspiring vision of the great internationalist. Wednesday, we travel to Chicago, and we're having a debate about whether the First Amendment protects hate speech, picking up on this great debate we had in D.C. on Friday about the future of digital privacy. And then programs on Hamilton's vision, the future of conservatism, culminating in Bill of Rights Day. It's going to be an amazing spring and fall. Okay, well, Cass needs very little introduction. He's the Robert Walmsley University professor at Harvard. He was the administrator of the White House Office of Information and Regulatory Affairs. He is one of America's greatest legal intellectuals, whose books, from discussions of Republic.com about internet polarization to his studies of polarization among groups, to judicial minimalism, have proved prophetic, illuminating, and creative. Ladies and gentlemen, please join me in welcoming the great Cass Sunstein. So, Cass, the audience chuckled when I said we were going to discuss this topic from a nonpartisan perspective, and yet the words Donald Trump do not appear in this book about impeachment. You have mentioned that you were more intensely engaged in this book than almost any other you have written. You wrote it over the summer in a concentrated burst. Why did you think it was so important to write this book, and what do you want to tell Americans about impeachment?
Well, I think that the origins actually are two. One is I clerked for Justice Thurgood Marshall. That was a great privilege a number of years ago. And he told me a story of meeting Prince Philip when he was just a lawyer. He wasn't Justice Marshall, he was Thurgood Marshall. And after shaking hands with Prince Philip said to him in the most kind of arrogant English accent, he said, "Would you like to hear what I think of lawyers?" And Marshall responded, "Would you like to hear what I think of princes?" And that stuck in my mind as saying something about the United States of America. That's kind of what we have in our DNA. Would you like to hear what we think of princes? And then the second origin was not long ago, 2017. I bought with my wife a house in Concord, Massachusetts, built in 1763. This is not a pragmatically good choice. With floors on the second floor that are tilted like this, they're like in a fun house, and crazy wires in the basement from when they first started having wires. that didn't really work, kind of made out of animals of some kind. And the house has ceilings which are made for people who are under 5'8". And so this was not a practical choice, but it's a house that was actually one of the places that British soldiers came on April 19th, 1775. They went to a few places in Concord, and they were smart to go there because it was hiding munitions. It was one of the places where the American Revolution literally started. And that fired me up about the origins of our country. And impeachment I thought of as, a kind of question mark. That's a little bit of the, the unanswered question of our constitutional heritage. Where did that come from? What's that about? And so in my kind of obsessive quest to understand what makes America exceptional, really? What is really the source of that, rather than a partisan rallying cry? I got into impeachment as a window onto what's our country about.
It's so striking that you begin with the American Revolution and you quote Emerson's Concord hymn, "By the rude bridge that arched the flood, their flag to April's breeze unfurled, here once the embattled farmer stood and fired the shot heard round the world." You say it's the third sentence, not the fourth, that most resonates with you. Here once the embattled farmer stood. Why is that?
Well, here's how our country started. You want to hear the story? I've studied this stuff, forever, and I had no idea that this is how our country started. April 19th, 1775, the fateful day, the British soldiers were going to several places in Lexington and Concord. Concord is where the munitions were held. The Americans were dedicated to protecting the munitions, but they were part of England. They weren't going to get in a shooting war with Britain. For one thing, this is within the family. For another thing, you kind of don't get in a shooting war with Britain. That was the greatest fighting force on the planet. But the British soldiers invaded, so to speak, conquered, and the Americans were kind of holding them off near the North Bridge, saying, "You're not going to go get our munitions. We're holding them here. Things aren't going well between us. No, you're not going to pass the bridge." And the British soldiers were armed to fight. The Americans didn't think there was going to be a fight. The British soldiers standing off against the Americans, who were up on a hill guarding the bridge, shot into the Concord River. The Americans thought those are warning shots, those aren't real. And the Americans were calmly saying, "We're not going to disperse." And then 30 seconds after, the British soldiers shot a volley into the American ranks. They killed a fifer. That's heartbreaking. I imagine him as a teenager, just on a little somewhat merry romp, and he's killed. And equally awful, they shot in the heart one of the two Americans who kind of knew how to fight. The British got lucky, and they killed him. He had 5 children there in Concord and a widow, and he was killed like that. At that moment, it looked like the Americans were going to be slaughtered if they didn't disperse. But a guy named John Buttrick, who was one of the other 2 people who kind of knew about fighting, rose to his feet. He wasn't on horseback. And he said, "Fire, fellow soldiers, for God's sake, fire." And what's kind of, I think, unforgettable about that line is twofold. First, for God's sake. You don't say that lightly in Concord back in 1775, and that was from the deepest part of his soul. The lives were on the line. And second, without even thinking, he said, "fellow soldiers." They were farmers. They weren't fellow soldiers until that moment. But gosh, if they didn't fire, with the word fire going like electricity through their ranks within a second after Buttrick said that, and to their own astonishment, they routed the British soldiers. They beat the greatest fighting force on the planet in self-defense and ran them off North Bridge. That's where our country started.
Your patriotism comes throughout this book, and your love of America. And I now have to ask the obvious next question. What is the connection between that patriotic story of the founding of America and the distinctively American conception of impeachment?
So the word impeachment sounds British, doesn't it? The idea that it's an American thing. Who would believe that? But it turned out that in the 18th century, the British had ceased using impeachment almost entirely. It was kind of a dead thing. But the Americans claimed it and used it. What did they use it for? They used it to fight the abuse of power. Whom did they use it against? They used it against instruments of the king, who were ruling over the colonies in a way that was an abuse of authority. And astoundingly, can you imagine the temerity and the guts that colonists in, this remote outpost started saying, we're going to impeach them. And impeachment meant they have to go because they are abusing the authority they have, because they're not respecting liberty, they're not doing what the law authorizes them to do. Here's what, for this author of this book, was a thunderclap. Read, if you would, the Declaration of Independence in light of the real shot heard around the world, which was the impeachment proceedings in the 18th century. That was the initial shot heard around the world. If you read the Declaration of Independence, it is the culmination of the Americanization of impeachment. The words, all men are created equal, are the culmination of what was happening in our country in a time in which the monarchical legacy, by which people who didn't have a lot of money or education, surrounded by people who did, they'd put their eyes down, they wouldn't be allowed to look them in the eye, and they thought that was life. You didn't look in the eye your betters. The notion of your betters, that was obliterated in these decades, and impeachment was part of it. So it was said by Thomas Paine, we see with other eyes, we hear with different ears. And one of the first American historians who was actually captured by the British in the American Revolution, something happened, which is we stopped being subjects and we started being citizens. And that changed everything. Read the Declaration of Independence in that light. The Declaration of Independence is the Americanization of impeachment. It is articles of impeachment. That's what the Declaration of Independence contains.
There was a debate at the Constitutional Convention about the meaning of impeachment. And as you note, the debate wasn't extensive. George Mason had wanted to introduce the word maladministration. Madison objected that was too vague, and the words high crimes and misdemeanors were chosen. What did Madison and the framers intend by them?
Okay, so it's humbling to talk about this here, yes, to talk about what happened in Philadelphia. What is noteworthy is that Madison's notes were pretty complete for much of the convention. He kind of ran out of speed or something, and he started doing summaries. So more might have been said than we actually have a record of. But what we have a record of suggests that the idea of limiting impeachment to treason and bribery, which was there as late as September, just treason and bribery, that was deemed unacceptable on the ground that there are dangerous and serious offenses that would not be treason and bribery. And you need to have some mechanism for that. High crimes and misdemeanors came in as the cavalry. It rescued a very difficult situation. And the fact that there wasn't a whole lot of debate about the term, on reflection, is not, I believe, testimony to the ambiguity of the term, but exactly the opposite. So if one says the word automobile in the United States, everyone kind of knows what that means, though there are many places in the world, whether they get English or not, who won't, that word is kind of ambiguous. High crimes and misdemeanors is not so different for that period than automobile is for us. That is, it was understood to have a history, a context. The fact is it was used in America. The people at the convention were familiar with impeachment proceedings in the states, and it basically meant terrible abuse or misuse of power. That's what it meant. And Hamilton explained it that way in the Federalist. The debates in the ratifying conventions, which were public, kind of nailed that idea and gave it concrete meaning. But if you think about impeachment and high crimes and misdemeanors, don't think, presidential crimes. Because there are presidential crimes such as jaywalking or shoplifting or even income tax fraud, which President Nixon was apparently guilty of, at least the IRS said so, not impeachable. That's not an abuse of presidential authority. None of that's good, but it's not what high crimes and misdemeanors are about. Also, you can have something that is not a crime, that is a high crime and misdemeanor in the constitutional sense. If the president says, I really like Paris, and I'm going to spend the next 8 months there, maybe call me if there's something really important, but Paris is where I'm going to be, that's impeachable. That's an egregious, in that case, neglect of presidential duty. So high crimes and misdemeanors meant really bad exercises or refusals to exercise the awesome power you have by virtue of being president, and that makes logical sense. The decision to create a powerful president, which was Hamilton's great victory at the Constitutional Convention, that was super controversial. So much so that it was described by critics at the convention as the fetus of monarchy, as an elective monarchy, as in John Dickinson's words, I'm paraphrasing here, a system more characteristic of England than the American Republic. Dickinson went for the jugular there. That's very tough talk. Without impeachment, no constitution, because impeachment was the necessary balance to the creation of a powerful president. It meant that the war for independence wasn't futile, that we weren't going back to the British system.
What were some of the examples that Madison and Hamilton gave of presidential misconduct that might be impeachable?
Okay, so Hamilton was a little abstract. He was a little like an academic, talking about abuse of power. Madison gave two examples in different moments which were super concrete. And the first was in the Virginia ratifying convention, when a critic of the Constitution who had refused to sign the document in Philadelphia said, and this is, historically momentous, because if Virginia went the other way, no Constitution. And the argument was made, because of the pardon power, we cannot have this Constitution. The president might advise terrible acts, and then the people whose terrible acts he has advised might be pardoned by him, and there's no recourse. And so the argument was, this is a fatal flaw in the Constitution, the breadth of the pardon power. And that's a formidable argument, isn't it? Madison, in what seemed on the page like a whisper, responded like this. He said, and it just reads so quiet, "The gentleman seems to have overlooked something." And then Madison said, if the president shelters someone who's done something sinister, the House shall impeach him, which was a clear signal by someone with whom it's hazardous to argue about the meaning of the Constitution, James Madison, a clear signal that abuse of exercise of the pardon power would be an impeachable offense. And basically that carried the day in the Virginia ratifying convention. Also, Madison said early in the Republic that wanton discharge of meritorious officials is impeachable. Meaning, if, let's say, President Obama decided, I'm going to fire, basically 18 people, not because they're doing a bad job, but because I'm kind of in a bad mood, or I don't fully trust them in some way. Keep it vague. That's Madison's impeachable territory.
And yet the first presidential impeachment, that of Andrew Johnson, involved Johnson's attempt to fire the Secretary of War, Stanton, in violation of the Tenure of Office Act. The Senate acquitted, and the Supreme Court later suggested that the act had been unconstitutional. Why do you believe that that was not a meritorious impeachment?
Okay, so recall what Madison said in the wanton discharge. He wasn't saying, you discharge one person who's good and you can be impeachable. He was more saying, if you go on a rampage of firing people who are good, then you're abusing your authority. So that would be different from saying, for the president saying, the Secretary of War, now the Secretary of Defense, it's not my guy. I don't want that person. And so Andrew Johnson was impeached for firing the Secretary of War under circumstances in which Congress had enacted a law saying that the president can't fire the Secretary of War. And what was really cute and kind of insidious in the law that Congress enacted is it said, and if the president does fire the Secretary of War, that's a high crime and misdemeanor. So it was paving the way for an impeachment proceeding. Now, when Andrew Johnson fired the Secretary of War, he was acting on the basis of a good faith belief that he had the constitutional authority to do that. Just like any president has the authority to fire the Secretary of Defense. And to say the president can be impeached for exercising either constitutional authority that he definitely has, or for exercising constitutional authority that he in good faith believes that he has, that would undo the separation of powers, yes? So the president has the authority to do a lot of things. If he does something that he has the authority to do, it's going to take a lot of words to show that that's an impeachable act. And even if he lacks the authority, but he's doing it in good faith, that's not an impeachable act, that's a mistake. And there's a difference. So a way to keep our, go to home base is, do we have an egregious misuse or abuse of presidential authority? And firing a member of your cabinet is not that.
And so just so I understand and I'm following, that's why an abuse of the pardon power could be impeachable. The president does have the authority to pardon, but if he uses it corruptly, it could be impeachable.
Right. So an example would be if the president said, I like police officers, which I hope all of us in the abstract do. They're serving us and keeping us safe. But then he says, okay, if a police officer is accused of racist killing, they are pardoned automatically. That's a problem, even though the pardon power is open-ended. If the president says, I'm going to pardon anyone who's accused of treason or bribery, that's a problem.
In an essay in the New York Review of Books, favorably reviewing your book, Noah Feldman and Jacob Weisberg suggest that the pardoning of the Arizona sheriff might be impeachable. What are the arguments for and against that?
Well, I'll have you know that the last year I've spent mostly between 1740 and 1800. So any reference to contemporary events I may or may not be up on. Having said that, the principle is not obscure, which is if the president pardons someone for engaging in, let's say, heinous acts that the president himself advised, easily impeachable. If the president pardons someone for engaging in heinous acts that are very closely associated with the White House apparatus, we'd have to fill in the facts in a certain way, but maybe in the domain. It would be a very hard argument, I think, to make, to say that a pardon by the current president or his predecessor of someone who did admittedly bad things, who is not closely associated with the president's personal decisions or the White House apparatus, it's a tough one to say that's an impeachable act. This is a way of saying that, we'd have to investigate facts in detail to reach a final conclusion. But there is a high bar, and that's good, against invoking the impeachment mechanism as a way of maybe leading to the end of a presidency. And a good check for anyone who thinks the pardon to which you refer is an impeachable act, a good check, a reality check is, if you think maybe, would you think the same thing if you loved the president and thought he was making one good decision after another? So we should have a principle of neutrality with respect to any impeachment conversation. And if people's judgment that President X should be impeached is affected by their dislike of that president on policy grounds, then they should probably take a deep breath.
You have 21 hypothetical cases offering your views about whether impeachment is appropriate. I know the audience is interested, so I'm going to continue down the Weisberg and Feldman list, and they suggest that alleged violations of the Foreign Emoluments Clause might be impeachable. You note discussion during the founding era of the Emoluments Clause and impeachment. What are your views, the arguments for and against impeachment for violations of the Emoluments Clause?
Okay, first we have to know whether the Emoluments Clause applies to the president, and this is a disputed question. The text of the Constitution is sufficiently unclear that people discuss without consensus whether it does. So there's that question. If the Emoluments Clause does apply to the president, there is one reference in the founding period suggesting that is an impeachable offense. And so if we have an unambiguous and, let's say, egregious violation rather than a technical violation of the Emoluments Clause, well, by historical standards, we are in the domain.
And when it comes to the allegations of Russian interference in the election, can the president be impeached for pre-election conduct or merely post-election conduct? And what about the allegation that, what would it take to make the Russia allegations impeachable?
Okay, I'm very conscious of the helpful discipline imposed by abstracting from a current controversy. So with your indulgence, I'm going to give you a variation, and then we can talk about the current controversy. So imagine there's a Democratic candidate in some future year who is in a kind of dogfight with a Republican candidate for the presidency. And imagine the Democrat is engaged in surreptitious conversations with China. And let's just imagine at the time, two facts are correct. One is that China and the United States are having competitive and unfriendly relationships, where the word unfriendly is an understatement. It's very rough between the two countries. And let's also suppose that, which is not false, that China has astounding technical capacity to find out what people are saying to each other. And let's suppose the future Democratic president coordinates with China to undermine the Republican adversary, so as to disclose secret stuff, so as to say things that aren't true. And China is basically super helpful to the Democratic candidate. That's definitely an impeachable offense. And the reason it's definitely an impeachable offense is historical. In the Constitutional Convention, in the very discussion that we were exploring, where the impeachment provision was basically guaranteed in one or another form, the example given was the president obtaining office by corrupt means. It says, shall he be able to obtain his office by corrupt means and after that repeat the injustice? And that was a decisive argument. Now, in the particular conversation, the example was corrupting the Electoral College and obtaining the presidency that way. But the case of enlisting a country with whom we aren't particularly friendly to do in a political opponent, that's worse. Which is a long way of saying, if a presidential candidate personally interacts with a nation with whom we are on friendly relations to procure the presidency through that interaction, that's impeachable. By the way, I have some recent, very tentative numbers. not nationally representative, but diverse Americans, suggesting that Republicans and Democrats agree with the founders on that point.
Because your issue spotting is helpful, I'll just ask, what about firing Comey? Under what circumstances is obstruction impeachable, and what would you have to prove to make that impeachable?
Okay, these are fantastic questions.
I'm eager for the answers.
What I hope everyone who's listening can appreciate is they're kind of fantastic lawyers' questions, but they're also fantastic questions for non-lawyers. And the impeachment provision, I think more than any provision in the Constitution, that might be a little bit reckless, as much as any provision in the Constitution, it's not a lawyer's provision. It's for we the people. That's the group it's for. And so let's talk a little bit about Director Comey. He's 6'10" and a man of immense integrity. So he was my student. I worked with him in the federal government. Whether he made good decisions or bad decisions, this is someone who is, very, very straight in terms of, he's not going to play politics. He might screw up, and I kind of think he did, but not for bad intentions. Okay, having said that, if a president, Democratic or Republican, fires the FBI director, that's at first glance completely fine. The FBI director is an at-will employee of the president. Second, for a president to fire Director Comey, given the, let's just say, controversial history of the previous year, and to say we want a fresh start, that's also fine. So far, it's looking good. To fire the FBI director, because the FBI director is conducting a lawful investigation into, let's say, somewhere between impeachable and heinous acts on the part of someone, maybe has nothing to do with the president personally. Okay, you can take it different ways. If it's obstruction of justice, I actually wouldn't make a fetish of the term, because you could imagine cases of obstruction of justice which wouldn't be impeachable if the president is obstructing justice with respect to the investigation of his own parking tickets or the parking tickets service, not impeachable. If it's not obstruction of justice, technically, it still might be impeachable if it's preventing a lawful investigation of horrible things. I think given the background of the Comey discharge, which is extremely complicated and has all the kind of noise and controversy associated with the FBI in the previous year, it would be very difficult to argue that's impeachable. If it turns out to have been obstruction of justice in the sense of an effort to obstruct a lawful investigation of impeachable or heinous acts, that's very grave. And so this is a long-winded way of saying that if the current special prosecutor, if White House counsel and Department of Justice would be extremely well advised to tell President Trump, with all due deference, Mr. President, do not fire the current special prosecutor, not because of any reason other, this is the first lawyer's thing to say, that's an impeachable act. Don't go there. Now, I wouldn't want to say that regardless of how the facts would emerge, that would necessarily be an impeachable act, but under imaginable scenarios, it would be. And so that would be a course of action that it would be extremely important to avoid.
Under what circumstances would firing Mueller be impeachable, and under what circumstances would it not?
Okay, so the easier thing to say, I regret this, so I should add, I worked for President Obama, and I feel that someone who worked for President Obama owes a duty of kind of caution and deference to his successor, and that's one reason. It's not the main reason, but it's one reason the book doesn't talk about President Trump. So it pains me to say that if President Trump discharged Robert Mueller, it would be presumptively in the category of the impeachable, because it's very hard to think of a reason to do that that isn't about self-insulation against an investigation of something that's extremely grave. And by extremely grave, I really am putting my finger on the Russia-US interaction and not saying that there's any reason to think that President Trump was involved in that. There isn't, so far as I'm aware, any evidence of that. But we do have evidence that a person who was working, it's to be hoped at a very low level for the campaign, was actually interacting with Russian officials about finding dirt on a Democratic opponent. Now, whoever you voted for, and this is not a negative about President Trump, it's about that person, you don't do that. I mean, for someone working on a campaign to engage with Russian officials about finding dirt on an opponent, whether you're Senator Sanders or Senator Cruz or, Congressman Kennedy or a Republican aspirant of any kind, you do not do that. That's a betrayal of your country. So, that if that's the kind of thing that's being investigated, to fire someone for investigating that kind of thing, that's really calling up the worst fears of the founders, which were about entanglements with other countries that were not loyal to our democratic process, let's say. Okay, now, if a special prosecutor is fired for abusing his own authority, or for not playing fair with prosecutorial discretion, let's say, or for being on some kind of genuine witch hunt, where an objective observer would call it a witch hunt, that would, of course, not be an impeachable act. So the hard case for those who would object to the discharge of a special prosecutor would be a president saying, I'm kind of trying to do my job here and serve the American people, and there's this person who's making life a nightmare. There's nothing here. There's some low-level person who did something admittedly awful, but now it's becoming a all-encompassing, diverting thing from the job of the President of the United States. We can't have that. Now, as I say, given where the circumstances are to make that argument, that is a neutral ground for discharge, doesn't appear to be easy. So if I were in the White House, I would say to the president, as I know presidents have been occasionally told over the years, there's an impeachment mechanism here and you don't want people to be thinking about it. Stay away.
Now, I have more questions about the current situation, as do the audience, but I have to share that your answers, remarkably judicious and nuanced as they are, seem unlikely to persuade the House and Senate. And indeed, you say that out of the 3 impeachments in American history, 2 were non-meritorious, Johnson and Clinton, and the one that would have proceeded to impeachment, Nixon, is the only clearly meritorious one. So is there an academic quality to this discussion? And what happens if Trump fired Mueller for corrupt reasons and the House refused to impeach anyway?
So there's a great psychologist who would have gotten the Nobel Prize, he died young, named Amos Tversky, who said, I'm an optimist, and it's rational to be an optimist, because if you're a pessimist, you suffer twice. Once when the bad thing happens, and once when you're thinking about it. So I think with respect to our institutions, we should be optimistic. And so I had some involvement in the Clinton discussions. I was, testified before Congress and talked to a number of members of the House, and I think some on the Senate side. And even though that was not, I think, a wonderful moment in American constitutional history, the Clinton impeachment, even at that not good moment, it is impressive to see the extent to which Republicans and Democrats both thought really hard about their constitutional responsibilities. So the Republicans who wanted to impeach Clinton and who voted to convict him in the Senate I think this was not something they probably look back on with a great deal of pride, at least I hope they don't, but they were thinking hard about constitutional text and history in Philadelphia. And they were trying hard to give an account of their judgment that fit within the constitutional context, and bless them for that. The Democrats, who by and large opposed, they were also very focused on the constitutional standard, and a number of them said, I don't have much enthusiasm for what President Clinton did, but it's not the kind of thing that got Madison and Hamilton interested in the impeachment mechanism. It's just a different fish. And they were talking constitutionally on both sides. So French social theorist La Rochefoucauld said hypocrisy is the tribute vice pays to virtue. Works in the household, works in the workplace. People will say something, even if they're hypocrites, but that's usable. They are paying a tribute to virtue. And in the Clinton impeachment, virtue got a lot of tributes, even by the hypocrites. And that's, in a way, promising. It suggests if something really grave happens, and let's hope it doesn't, but if something really grave happens in the next period, that kind of fixation on what the Constitution means, I expect we'd see profiles encourage.
I can't resist sharing. I also testified during the Clinton impeachment, and it was a terrible tragedy because Alan Dershowitz was testifying right next to me. And at a dramatic moment, he stood up and flung his hand across the room, totally blocking my face in the picture in the Washington Post on the front page the next day. That is a tragedy.
Well, that would be impeachable were he president.
It was that really my one chance. Who knew? Actually, are the failure of Clinton and Johnson impeachments and the likely success of the Nixon a sign that the system actually works?
I think so. So you might think, we've had 45 presidents, only 3 serious impeachment inquiries, so it might look like a dinosaur, it kind of extinct, Tyrannosaurus Rex, impeachment, same family. But 3 out of 45, statistically, it's not that small. We have a small sample here. And notice also, in terms of system works, what's said of the sword of Damocles, it's not important. What's important is not that it falls, but that it hangs. The sword on your head, and impeachment is a sword on presidential heads, and it has kept them at times from going in areas that they've been tempted to go. The fact that it worked in the Nixon case, which was the most egregious, certainly of the modern cases, is a tribute. I do worry a little bit, though, about 2 things, and with your indulgence, I'll tell you which one I worry more about. One, given the speed with which fake news spreads, we could see in, the next 20 years, an impeachment effort that is politically motivated and completely baseless. So we could say an energized populace basically disliking the president and going after him or her because of something that has gone crazy on Twitter of the 2020s. That would be bad. And that would destabilize the system in a way that would be, given the role of the United States in the world, be awful. But there's something else I worry about more, and some of your questions signal this. Imagine that we had, in the US, a clearly impeachable act. It could take the form of something like an abuse of the pardon power, which is bad, or the unlawful and, let's say, impeachable discharge of someone who's trying to undertake a very important investigation, or worse, it could take the form of an abridgment of liberty. And I say that's worse kind of with historical lens, because in Massachusetts, where you remember fire, fellow soldiers, for God's sake, fire, during the ratification debates, someone who's not very famous, in fact, he had a pen name, Cassius, wrote, okay, suppose there's terrible violations of liberty, that's what impeachment is for. And that's kind of searing, I think, words, and searing in a good way, they're engraved, I think, on the American psyche, that concept, if not the particular historical account. But suppose a president does something like that, something that called up what happened in the ratification debates to say this is what impeachment is for. Would we impeach such a president? What if the House of Representatives is controlled by the same political party of the president? Would we impeach that president? We don't know. And that's worth worrying over.
Well, that points to the deep democratic roots of impeachment. And you're pointing to two really dangerous possibilities, that there might be defects that make the democratic deliberation that the founders relied on for the whole system to work impossible.
Yes. I needed to drink. This isn't water. This is bourbon. This is straight bourbon. You thought it was water? Okay, so the concern is that we would either get all charged up and, let's say, do an illegitimate impeachment, or that we'd let someone stay under circumstances in which things are going really sour. I think that's very, very unlikely for a couple of reasons. Our institutions are such that for a president to abridge liberty in a very serious way is challenging. Not impossible, but challenging. First, because the president worries about what the people think. Second, because Congress makes the law. And third, because the judges are there. Maybe of all these, the most important is the constraining effect of public opinion. So presidents who have been tempted to go various places often aren't because of the check that we, the people, are, we're watching. And to have a sense, I think, of the fire of the 1750s, 1760s, 1770s, in which self-governance and the equal dignity of human beings were kind of born. That's American exceptionalism, and the Star-Spangled Banner yet waves.
You quote a mutual hero of ours, Louis Brandeis, on behalf of the proposition that public discussion is a political duty, and that deliberation is key to those who won our revolution. Do say more about the fears of the technological and institutional changes that might be threatening that kind of deliberation, and therefore the impeachment power along with it.
Okay, so this is, as important as any question there is. So you can think of our constitutional system as a deliberative democracy, which means that it puts a premium on reason giving and justifications for action. That's deliberative. But it's also democracy in the sense that we, the people, are ultimately in charge. You could imagine a non-deliberative democracy in which majorities just get to do what they want because that's what they want. Yes? Sometimes America seems a little like that. Or you could imagine a deliberative non-democracy where there's a lot of deliberation going on in government, and it's really good and informed and expert, but we, the people, don't have much of a role. The deliberators do what they think best. So what our system is, and I think it is the greatest contribution our system made to political thought, is it tries to merge deliberation and democracy. And I observed in my time in government, at least at times, it works magnificently. Where there's a problem we're facing, it could be a crisis of Ebola going on through the world, and the United States played a crucial role in worldwide licking of Ebola. It's basically been ended, the crisis. And the deliberative process in the United States, where there was a lot of thinking, but also the president personally, the most visible elected official was the ultimate decision maker with respect to executive branch policy. And we, the people, were actively engaged in worrying over Ebola and thinking what to do about it. And it worked. So that's a success story. And there are probably in the last 10 years, 1,000 of them, some of them really small. TSA pre and global entry. So the experience of flying is now much better than it was without those programs. That's deliberative democracy, where there's a process with the executive branch and Congress and we the people thinking, how do we make the air transportation process more rational and less cumbersome? And TSA pre and global entry are two small examples that did that. And so that's good. Okay, where deliberative democracy doesn't work is when elected officials are so tied to re-election that their capacity to deliberate is effectively eliminated. And I saw this too at times in Washington where people would say in closed doors, of course that's a great idea. I'm voting against it. And they weren't being, just erratic. They were saying, I have to vote against it. I'm going to lose my job if I don't. And so their ability to deliberate was weakened. And there's no question that contemporary social media can be an aggravator, where if they're going to get hammered on Twitter and Facebook, that may be like a notice that they're going to lose their jobs. There's also a risk at times that the capacity for self-governance is compromised when we, the people, are insufficiently engaged because we've got a lot of stuff to do, live our lives, love our families, do our jobs, and when we're not paying attention. So both the democratic component and the deliberative component can be challenging.
I have so many more questions on this score, which is the subject of our commission that I've told you all about, the Madisonian Constitution for All, and we'll hope to get Cass back to address this broader failure of deliberation, but I've monopolized the conversation, and there's so many great questions, and let me put several of them on the table. What if instead of firing many people, a president just never fills many positions in his administration, weakening the government? Would that be impeachable? Let me just put a few more on the table. Can the president be indicted and convicted during his term for a state crime? And was not the action to fire Comey an impeachable act? So just to remind you, the first one is, what if he just didn't fill a lot of positions weakening the government? Would that be impeachable?
I don't think so. So if the president decides, there are a lot of jobs that we kind of don't need to get filled, and I'm going to do my job and the executive branch is going to operate, but we're going to save taxpayers' money, that's not an impeachable offense. If the president announced the federal government is basically going out of business or something like that, then we're getting to egregious neglect of duty, but it would have to be very extreme, not about not filling positions. Okay, the Comey question, it is a very discussable question. And what makes it confusing, the Comey question, I think, though I've been stuck in 1770s, but so far as I've been keeping track on Twitter of what's happening, you can rely on Twitter, yes? My understanding is that the reasons given for discharging Comey have not been the same. So forgive me if I'm not getting this right, but I think the reason given by the Deputy Attorney General, who had the authority to fire Comey, was that he went after Secretary Clinton too hard with disclosure of emails. And that would be by itself a hardly impeachable ground for discharge. It would be completely within the domain of, let's say, Deputy Attorney General / presidential prerogatives. But my understanding is the president later said something completely opposite, that it was about Russia. Now, to go behind the competing statements of various people in the context of an impeachment proceeding, especially when we now do have a special prosecutor in place who's doing the investigation, I do not think it would be very challenging to turn this into a justified ground for impeachment. You need to generate lots of material that showed the ground for impeachment, the ground for discharge was clearly illicit. So this is a long way of saying the Comey discharge, it's very hard to make that into an impeachable offense. The Comey successor, so to speak, not literally, but the current investigator, that would be a much cleaner case for a legitimate claim. This is an impeachable offense, depending on the factual scenario that prompted it. That's really a law professor's answer, isn't it? I'm sorry.
No, it was and the third one was, can the president be indicted and convicted during his term for a state crime?
No, no, no. No, exclamation point.
Huh. A clear answer.
You want an explanation? I was trying to give a non-law professor answer.
Yeah.
The best reading of the Constitution, though this is not unambiguous, is that the president cannot be indicted while being president. And the reason is the president is president. He kind of has to do his job. And if he's indicted and threatened with a criminal prosecution, that kind of takes over the mind. Can't do his job. So an inference, I think, from Article 2, the best inference, is prosecute him afterwards.
You have a wonderful last chapter where you answer questions like these, and here are some more. Can the president pardon himself? Would that be an abuse of power?
The president cannot pardon himself, and that would be an abuse of power. And the reason is that the pardon power has a particular set of functions. Basically, the president can be Portia in The Merchant of Venice. The quality of mercy is not strained. Kinda. So the president is allowed to exercise mercy. And there's something really beautiful about that. And the ability to second guess the exercise of mercy is very close to zero. The pardon power is extremely broad, but there are two restrictions, I would say. One is the one that Madison specifically called up, which is abusing the pardon power so as to shelter people who've been engaged in horrific acts, especially if they are horrific acts that involve the president's personal participation. There were impeachable. And there's a long-standing prohibition on self-dealing in Anglo-American law, that you're not supposed to be judging your own cause. And while this isn't crystal clear, the better view I'm suggesting is that the prohibition on self-dealing carries over to the pardon power. That's not what it's for.
What is the recourse if there are impeachable acts and Congress fails to take action?
Well, I'm trying to think, what are the first three words of the Constitution? Remember, we the people. So if Congress fails to take action, I'll give a too simple account. The reason is that it's not in the incentive. The incentives aren't right for Congress to take action. So if the House declines to undertake an impeachment proceeding, it's because the House doesn't want to undertake an impeachment proceeding. And if the House doesn't want to undertake an impeachment proceeding, it's because people aren't demanding it. And a switch would occur if and only if people demand it, if their jobs are on the line. The Nixon example is instructive here, where a large number of Republicans who were loyal to President Nixon, who, by the way, was in many ways a great president, both domestically and internationally. We shouldn't lose sight of that. That makes the impeachment proceeding, which led to his resignation, all the more remarkable. That Republicans, non-trivial numbers, said, you know, he's our guy, but he's done these things, and they're impeachable. And it wasn't only an independent judgment. It's that voters thought this is not right.
Remind the audience which of the Nixon articles of impeachment were closest to the core of the impeachment power.
The one that is the strongest is the use of the apparatus of government to go after political enemies. So the claim was the president used the FBI, the CIA, and other parts of the government to punish people who were politically opposed to him. And that's really recalling the ratification debates. That's compromising democratic self-government itself. Obstruction of justice in the form of resisting lawful efforts to figure out whether the Watergate affair had occurred, that's not as clean a case for impeachment. Recall, we're not talking there about the kinds of abuse of presidential authority that got Madison, Hamilton, and others really exercised, but it's pretty close.
You note that one of the less impeachable charges against Nixon was the IRS's finding that he had underpaid $400,000 in taxes while he was in office. I couldn't help but ask, how did the IRS find that out, and how'd they get his tax returns?
Well, the IRS, you know, they know stuff. And notice, if you would, $400,000 in 1970s money, that's, I did the arithmetic, that's $9 trillion now. So that was a very significant underpayment of taxes. How did he earn that much, Nixon? So $400,000, that's a very substantial underpayment. How they knew it, they know. Are you worried now? They know. That is, some of the Democrats thought that's an impeachable offense, but it just isn't. And the reason it isn't is that anyone, sad to say, could underpay their taxes. It's not an abuse of presidential authority. It's not like going on vacation in Paris, violating civil liberties, making war, or pardoning people on the ground that, you know, certain lives don't matter. That wouldn't be acceptable.
Well, I have so many more questions, and the audience does too, but we need to get you downstairs so you can buy and read this wonderful book. So I'm going to ask one last question, and there's an opportunity for some concluding thoughts. The question is essentially, do you agree with Gerald Ford's famous statement, impeachment is what the House says it is? You've suggested that that's not quite right, and you've also disagreed with Nancy Pelosi's claim that impeachment has to be criminal. So remind the audience what is impeachable, and then really I think we all want to know this. What are your thoughts about whether this system will work, and do you have faith or not that the impeachment system, so crucial to American popular sovereignty, will function in the anxious months and years ahead?
Okay, so Nancy Pelosi, whether you agree with her or not, she's been a dedicated public servant for a very long time and is a student of government and the Constitution. She made a big mistake in saying that the impeachment question is a question of whether the president has committed a crime. There are plenty of crimes that are not impeachable offenses, and there are plenty of non-crimes that are impeachable offenses. So it's about, as Hamilton said, abuse of trust, which means abuse of authority, and I think we have to say egregious, meaning awful, abuse of authority, abuse of trust. So crimes can be impeachable offenses, but that's not what the thing is. That's not the thing you should be staring at. You should think egregious misuse of authority. Gerald Ford, who was in many ways also a great man and an American hero, made, I think, an even worse mistake, actually, in saying that an impeachable offense is whatever the House of Representatives says that it is. The whole point of the debate at the convention and in the ratifying discussions was, no, this is a legal concept. The House could try to impeach someone because they thought the person's a terrible president, or because they thought the person is supporting legislation that's awful, or because they thought the person's horrible to work with, or the person's abusing his employees. None of that's impeachable, even if the House thinks it is. So the way to think about it is that they really threaded a needle, the founders, and at least my sense reading the debates, both in the convention and the ratification period, was astonishment that they had so many things to figure out. And this was just one of 140, and they nailed it. I think they really figured it out in a way that it would be very hard for a large group of people who had 10 years to improve on. And that Pelosi's view would lead to an inability to impeach a president who refused to do the job. That's not right. Ford's view would lead to the impeachment of the president who just disagreed with the majority of the House all the time. That's not right either. Okay, in terms of faith in our country, I guess I'll say that that what I learned over the past year, I worked for President Obama. I have great admiration for him. He gave wonderful speeches about American exceptionalism, in which he said, American exceptionalism is our capacity for self-reinvention, and that we learn from mistakes and we go embark on new directions. He said it much more eloquently. But he was wrong. That's not American exceptionalism. Some Republicans have said something about what American exceptionalism is, unlike Europe or something. We believe in, private property and freedom of contract and restrictions on governments of power to go into the private domain. That's true about America, but that's not American exceptionalism. What American exceptionalism was born in those very tough, inspired days in the 18th century when republicanism was on the march. And what it has to do with is two things. We are a self-governing people. It doesn't matter how much money you have or how much education you have. You are part of a self-governing people. And second, a commitment to the equal dignity of persons. And that is living and breathing in this room and in our culture. And wherever you were born or wherever your parents were born, if you're an American citizen, you have a link with those embattled farmers. They're kind of in you. And so it's going to work out.
Ladies and gentlemen, for his patriotic scholarship, please join me in thanking Cass Sunstein.